Okay, so today we're going to dive into summary judgment in South African law. And, we've got some really interesting sources here. Have you ever thought about, like, how someone can get a really quick win in court when a case is just super obvious? Well, that's kind of what summary judgment is all about.
Yeah, that's a great way to put it.
So we're going to look at, like when and how this actually happens in South Africa and how the legal system kind of balances things out, making things efficient, but also making sure everyone still gets a fair trial.
Absolutely. And, think of it as a way for the courts to deal with cases where the plaintiff's case is just rock solid. Like, it's so clear they should win that having a whole trial seems like a waste of everyone's time. So, we're going to look at exactly when and how South African courts allow this to happen while still, making sure everything is fair and just.
All right. So let's say you're in a situation where it's pretty clear that someone owes you money or they need to give you something back. When can you actually go for this summary judgment thing?
Hmm.
The text talks about unquestionable entitlement. So what does that actually look like, in real life? Like, imagine you're a freelancer and you have an invoice that's way overdue.
Yeah, so there are a few specific types of claims where this comes up. Unpaid invoices, like you said, they fall under what's called liquidated debts. If you have a contract that clearly shows what's owed
Yeah,
and you have proof that the debt exists, then you've got really strong evidence.
right.
Another example is when someone has something that belongs to you and they won't give it back, like say your laptop or something. We call that specified movable property. You can totally prove it's yours, then you might be able to get a summary judgment. And then there are claims based on what we call liquid documents. These are things like checks that bounced, because the document itself proves the debt. These cases can also qualify for summary judgment.
Okay, so those are like pretty straightforward situations, where it's pretty obvious who's in the right. So let's say someone thinks they have one of these strong cases. What do they have to do to actually try and get a summary judgment? What's the first step?
So the first thing the plaintiff has to do is file an application with the court. And a really important part of this application is something called a sworn affidavit.
Oh, yeah, I've heard of that.
Yeah, so this is a document where they basically swear under oath that their claim is legit, and really importantly, they have to state that they don't think the defendant actually has a real defense.
So it's like they're saying, look, there's no real argument here. I'm clearly in the right. So what about the defendant? How do they get a chance to respond and maybe avoid this whole summary judgment thing?
Well, that's where the idea of a triable issue comes into play. The defendant has the opportunity to convince the court that there's something that needs to be figured out in a full trial. Like maybe there's a real question about the facts of the case or about the law. So going back to your freelancer example, if the defendant says, hey, those services weren't actually done right, that could be a triable issue. They need to show the court that their defense isn't just some kind of delay tactic, but that there's a real question that needs to be answered.
That makes sense. It sounds like the courts are really careful about just granting these summary judgments right away. The text actually says they're very careful. Why is that? Why are they so hesitant?
Yeah, it all comes down to protecting the right to a fair trial. Summary judgment basically bypasses all the usual steps of a trial, so the courts want to be absolutely sure there's no real dispute before they do that. They'd rather have a full hearing, even if the defense seems a bit weak, just to guarantee that everyone gets their chance to present their case.
I see. And it was really interesting to read that even a weak defense can sometimes be enough to stop a summary judgment from being granted. Why is the bar set so high?
That's a great question, and it really shows how much the courts value due process. They don't want to stop anyone from having their case fully heard. So even if a defense seems kind of shaky at first, the defendant still gets the chance to explain everything and maybe bring up some valid points during a full trial.
Okay, so if we had to sum up everything we've talked about so far, what are the key takeaways about summary judgments in South Africa?
I think the main point is that it's all about finding a balance. Summary judgments are meant to make things more efficient, saving time and money in cases that are really straightforward. But that's always balanced against the right of the defendant to have a fair trial. The legal system really wants to make sure everyone gets a chance to be heard.
Yeah, that makes sense. And it's interesting how this whole thing about balancing efficiency and due process comes up in other areas of life, too. Like, we see it in all sorts of systems. It makes you think, where else do we see this same kind of tension between needing things to move quickly and making sure everything is fair? What happens when we focus too much on one side or the other? It's definitely something to think about. Thanks for exploring this with me.
You're welcome. It's been a great discussion.
All right, that's all the time we have for today. Thanks for tuning in to this deep dive.